clearly, you gave us very clear indications about where your concerns lay, and as a responsible public body, we are considering those comments. If I might move on to just looking at the provisions and come back and address you on certain priority points which are very concerned to you, perhaps once my clients have had a chance to think about it overnight, that would be most grateful for that. So I was going to take you through IRC and Chater, bracket and Chater, as it's otherwise known. It's actually been put on your desks, I gather?
Yes, it is.
And this is, I slightly, so before lunch, I think my Lord Henderson said that we just scraped in over the definition of transfer of assets and into the transfer of assets code. And I cited several authorities, one of which is IRC and Chater. IRC and Chater is the authority that we rely on in the context of transfer of assets. I also happen to mention the Haley Mills case as well as the Crosland and Hawkins case. Those were settlements provisions.
That's what I thought, yes.
Absolutely, my lord. But as you will also know, my lord, the definition of settlement includes a transfer of assets. In section 620 Itoya. I don't know if we have it in the bundle because it's not a relevant provision here.
But we're already getting quite a long way from the transfer of assets provisions. I mean, the point is, I quite take your point that the definition is very broad and does include the creation of assets. Even that leaves one wondering, well, what exactly is the asset in a case like this?
Well, perhaps if I could take you through
no doubt you'll find the answer. Yes.
Absolutely. So if IRC in bracket, the facts are set out on the first page, in the summary. Might I just invite you to cast your eyes down that? And then I'll take you through a couple of the passages once you had a...
So delimited is the employer,
Yeah.
the taxpayer works for delimited. And
Taxpayer works for delimited, drawing no salary until his 70th birthday, and certain other things are done for him. Yeah. Query whether or not the transfer of assets provisions could be said to apply to him, and the Special Commissioners had said no, and Mr. Justice Hoffman, as he then was, his decision starts at page 536, and he summarised the facts starting at page 536 around G. But given that you've read the facts, I would suggest that we move on to the analysis. So that's at 538, around the letter, just below the letter F. The Special Commissioners held that the taxpayer had failed to show that tax avoidance was not a purpose of the transactions, but they discharged the assessments because they considered that there had been no transfer of asset by the taxpayer to Drishan, and in any event, no income had, in consequence, become payable to Drishan. Section 4788B, which is the equivalent of the definitional provision for ITA, said, gives an extended meaning both to assets, which include property or rights of any kind, and to transfer, which in relation to rights includes the creation of those rights. And then he sets out the revenue submission. The Special Commissioners rejected this argument on three grounds. First, they said that the taxpayer's earning capacity was not an asset in respect of which rights could be transferred or created in favour of Drishan. This suggests that the rights of any kind, which can constitute assets under section 4788, and we say under section 716 here, must be rights in rem subsisting over some other assets. I can see no basis for this restrictive interpretation. The Special Commissioners found, in my judgment rightly, that the contract of employment conferred on Dreshan enforceable rights against the taxpayer. O'Brien and Benson's hosiery shows that such rights can be assets for the purposes of a disposal under the capital gains tax legislation. In my judgment, they are equally rights which qualify as assets under section 478. Second, the Commissioner said that the rights acquired by Dreshan were not created by the taxpayer because they came into existence under a contract to which he was only one party. This too, in my view, is an unduly restrictive construction. The contract of employment is no doubt a bilateral transaction by which each party undertakes obligations and thereby confers rights to the other. In the context of 478, and in particular the extended meaning of assets contained in subsection 8, it seems to me appropriate to describe the rights of one party under the contract as having been created by the other. Third, the Special Commissioner said that the contract did not result in income in the sense of profits or gains of the trade of business consultancy becoming payable to Dreshan within the meaning of 478. All that became payable was the receipts of the trade. The profits arose in the hands of Dreshan as a result of carrying on the business. The Commissioners distinguished Latilla on the grounds that in that case there was a partnership which constituted a distinct fund out of which the taxpayer was entitled to share of profits. Although there are references in the speeches to the income having been paid out of the partnership funds, I do not think that this was an essential element of in the reasoning. A partnership is not, after all, a separate legal entity. We, of course, are not concerned with partnerships here. The receipts of the partnership belong to the partners immediately they are received, and the profits of the partnership arise to the partners in exactly the same way as in the case of a sole trader. What the House of Lords did in Latilla was to reject the submission that it was not conceptually possible for anything other than the receipts of the trade, as opposed to its profits or gain, to become payable to the trader, and that therefore 478 could not apply to trading profits. So in Latilla they'd said, trading profits, you can't be within the scope. The judgment of Mr. Justice Lawrence, which was approved by the House of Lords, seems to me to deal with this argument on the quite general basis that in the context of 478, the words income becomes payable to are wide enough to include not only the case in which the payment to the non-resident has in itself the quality of income, but also the case of payments to a non-resident trader from which, after deduction of expenses, the income will arise. So the income becomes payable to, we say, in this context, in 716, is income will become payable to, i.e. in the sense of profits.
Yes, but until then, it will not be income for the purposes of the section. I mean, that's also implicit in what Mr. Justice Hoffman is saying.
My Lord, I don't dispute that.
Okay.
I don't dispute that. I mean, we accept that it's supposed to be profits when we're looking at traders.
Yes.
The term income in
Yes.
4716
Well,
for a trader means profits.
Yes.
We're not denying that.
Okay.
It's a question of timing then, and that goes, as it were, to the priority argument, which, as I've said, we've parked for the moment.
But if I may say so, it's not just a question of timing, because you can't suppose before you have the computation of profits that there are going to be any. So it's not just a question of when, it's a question of whether. Because until you have a computation of trading income, you have no income at all chargeable to income tax.
Which is why, my Lord, I thought it worthwhile bringing to your attention the concept that income will arise, i.e. that it's the sort of quantification, the amount the income becomes payable to is broad enough to encompass.
Also, from which. I mean, as I understand it, there was no issue in that case as to at what point in time income arose for the purposes of the section. I mean, there were these three separate arguments which Mr. Justice Hoffman considered and rejected. But there was no question of priority, or as I think you would have it, between the charge under section 478 as it then was, and what would then have been the Schedule E charge to income tax.
My Lord, you're of course absolutely right. It wasn't a live issue in that case, but we say that his expression of what the words income becomes payable to in the context of 478 are capable of encompassing is trading profits as and when they are computed.
Well, maybe we're not disagreeing as long as you accept it is as and when and not before they are computed.
Yes,
you have any income for the purposes of the section.
My Lord, absolutely.
Okay, thank you.
So the next point that I wanted to go to, in my Lord Phillips, I trust that this covers the concern about whether or not the transfer of assets is broad enough to cover the creation of rights under an employment contract.
Well, as I understand it, there's no dispute that for today's purposes, that this is the appropriate principle.
Absolutely, my Lord. So the next question is, what is it that is attributed to the individual? It's not all of the profits of a trader. It is the profits of the trader which the individual, who is the transferor, has a power to enjoy. And so when one looks at that, power to enjoy is defined in section 723. Well, it starts at 722, and what we have is page 456 of the same. It's tab 8A of the legislation bundle.
Yes.
And do you have that, my lady?
Yes.
So 722 sub 1, for the purposes of section 721, an individual is treated as having a power to enjoy income of a person abroad if any of the enjoyment conditions are met. And then we're told in sub 2, conditions A to E in 723 are the enjoyment conditions. For 723, we say are broad enough certainly to encompass the purported, I take back the word purported, the loans that were made to Mr. Hoey, and let me explain how. They either fall within condition A, is that income, i.e. the profits, is in fact so dealt with by any person could be the employer, as to be calculated at some time to inure for the benefit of the individual, whether in the form of income or not. Or it could fall within D, is that the individual may become entitled. So it's a potential to benefit. It doesn't have to be benefit. It doesn't have to be an entitlement currently either, because what it goes on to say is condition D is that the individual may become entitled to the beneficial enjoyment of income if one or more powers are exercised or successively exercised. So that contemplates, we say, a broader set of arrangements where at this particular moment in time, it isn't clear how the profits are going to be deployed. But if it is possible for the individual to be able to receive them, say because he's a beneficiary under the terms of a trust, or say because he is an employee in respect of a company that has an employee benefit trust of which he may be a beneficiary, then the successive exercise of discretions or decisions made by people, the one or more powers exercised or successively exercised.
But surely, I mean, all of these conditions presuppose that you already have the income in existence. And then you don't have that until you've got your computation of trading income.
May I put it in these terms, my lord? I'm not disputing any of this with you.
Well, in that case, if you're not disputing it, I can't at the moment see how any of these conditions could be satisfied, because they're all predicated on the fact that the income is dealt with or may lead to beneficial enjoyment or whatever. So until you have that income, there's nothing for the section to fight on.
So what we would say, my lord, is that we know that there are gross fee receipts.
Yes.
We know that Mr. Hoey received something, i.e. the loans, and he didn't expect to have to repay them. He's accepted that they were payments to him. When you look at the transfer of assets provisions, there's certainly gross fee receipts and there's a benefit to him. The only bit that we're looking, and that's the amount he had the power to enjoy. Query is that something that is to be deducted in arriving at the profits of the offshore enterprise, or is it not? And that's why the wholly and exclusively question comes in. So all we're looking to say is, when we look at what of the expenditure that we do know about was incurred by the offshore employer, is capable of being applied for Mr. Hoey's benefit, and which is not a permissible deduction. Because then we know, working as it were backwards, that there must be profits of the person abroad.
Well, why would that be? What if, even if you don't deduct the payments of the EBT, the employer is still making a loss?
But he doesn't have the power to enjoy that. That's the limiting factor here. The income, the profits will be attributed to him to the extent that he is capable of enjoying them, or does in fact enjoy them.
But there have to be profits for him to enjoy.
May I put it in these terms? I'm not denying that, my lord. So in a given year, you have receipts, you have expenditure. The deduction or not of those will need to be determined on general principles for traders. Then you then compute the amount of profits. When you've computed the amount of profits, you then ask yourself, what part of those profits did the individual have the power to enjoy? And you say, well, he definitely had the power to enjoy that which he received. You then ask yourself, if that which he received is a permissible deduction in the hands of the employer. So it's when we deny the deduction, can we say that there is a profit? Until the time at which we deny the deduction, clearly it looks like there's zero sum because
my question is, what if when you deny the deduction, there's still no profit?
If you deny the deduction and there is still no profit, then there is nothing for him to have benefited from. There is no income of the person abroad.
No, exactly.
Capable.
But we don't know the answer to that.
But my lord, there are two answers to that. One is that we know that he received something that he had the power to enjoy. We have that concrete bit of evidence. We also have the evidence of some of the contracts which show that he was earning a certain amount a day. So there was certainly fee income being received. It's not denied that there was fee income being received. So by the offshore employer. So there were payments made out to the EBT, which were then made to Mr. Hoey. There are therefore flows of money, and we can therefore carry out a computation to that extent. It may be there was more profit than we're aware of. It may be that there was less profit than we're aware of. The only point that we're making is that when it comes to looking at what Mr. Hoey had the power to enjoy, he had the power to enjoy certainly the amount of the loans that were made to him. The question is that sufficient to give rise to a charge to tax under 721? And we would say that it is because the basis upon which the profits are calculated will exclude a deduction in respect of that loan. And as my learned friend, Mr. Brzezinski, reminds me, there was no evidence that, and it was never asserted or proven that there was ever a question of a loss arising. So once you deny the deduction, as we say is appropriate to do, there cannot but have been a profit.
May I ask another possibly inappropriate question? We're looking at the question of wholly and exclusively. But when one's assessing the profit of an Isle of Man company or a Guernsey company, you presumably apply the law of the Isle of Man or of Guernsey.
My lord, we apply the principles of UK law in applying the tax rules. I'm trying to remember.
That's Chetwood again, I think.
I think it's Chetwood.
My thoughts are running along exactly the same lines as my lord's until I looked at Chetwood, and I think that's the answer to that. Because it's a UK statute dealing with avoidance of UK tax, it's appropriate to
apply UK
construe the concept of income in accordance with UK tax law principles.
Yes, my lord. And one might say, there's evidence of that in other areas as well. For instance, when one looks at Bray and Lazard and partial liquidations and the character of income, you work it out on the basis of the foreign law as a matter of fact, and then the characterization in the UK under UK law, because it's a UK statute ultimately. So I would say that we apply UK principles in determining the quantum of the profit.
I mean, speaking for myself, I'm content to proceed on that basis, although I can see the attraction of the view that one, if you're looking at an Isle of Man company, you need to go and see what Isle of Man law would say about the computation of profits. But anyway, nobody seems to have taken that on.
That point has certainly not yet been taken, my lord.
But even so, that then leads to the problem which I've been mentioning to you, no doubt you're feeling ad nauseam.
At what point are the profits? And so,
yes.
Yes, my lord. And I see what you're saying. And quite apart from the priority point, the quantum, if one starts from the position that there is definitely income, there is no suggestion that there is income in the sense of receipts of the person abroad. So
Right.
Gross receipts, there has been some expenditure. There has been no suggestion that there are losses. So on that basis, if one proceeds on the basis that the expenditure is denied as a deduction, the only outcome can be profit. Then the limitation is, in terms of the charge under 721, is on the extent to which what remains as profit in the hands of the offshore person is, as it were, profits that the individual has the power to enjoy, i.e. the income of the person abroad that the individual has a power to enjoy.
Yeah, and once you get to the stage of having an identifiable profit, then I think the power to enjoy seems to follow pretty clearly from the provision of the loans.
Yes, my lord.
But what I'm still jibbing at is the proposition that a loan without more can be treated actually as part of the employer's profits, and it's just a trading outgoing.
My lord, if I may put it like this, it's certainly an expenditure. And if one was doing an I minus E, one would say I minus income minus expenditure, you would arrive at a figure. That is broadly what one would do under GAAP as well. But then it is subject to UK tax rules. And it is the UK tax rules that say you cannot have a deduction, which you might otherwise have, if it's not wholly and exclusively for the purpose of the trade. If I could move the conversation on, perhaps, to the wholly and exclusively argument, and then address you on that, in order to make good our point that this is not a permissible deduction. So ex hypothesi, there is profit of the person abroad, which is the profit that Mr. Hoey has the power to enjoy. Then perhaps we might even end up in some agreement. Who knows? But if I might then take you to section 34, I think is a good place to start. So legislation tab 6. We've used section 34, my lords and my lady, as opposed to, say, section 54, because 54 applies, section 54 is in the CTA, applies for corporates, i.e. companies within the UK charged tax. This is a non-resident company, so section 34. Itoya, we say, is relevant, and what that provides is that in calculating the profits of a trade, no deduction is allowed for expenses not incurred wholly and exclusively for the purpose of the trade, or losses not connected with or arising out of the trade. So of course we're not concerned with losses here, there's no suggestion of that. So it's a question of, is a deduction available for the expenditure of payments to the EBT? Are those wholly and exclusively for the purposes of the trade? And it's common ground here that there is a trade being carried on by the offshore entity.
But what is that? Is it common ground what that trade consists of?
Well, I was just coming to that, my lord. It's been characterised by the upper tribunal as the trade of providing services to of its employees to end users in return for fees, and that is at UT. That'll be in the core bundle, tab 11. And the upper core bundle, tab 11, between paragraphs 217 and 219. So at around the letter between H and J, HMRC in any event make the fair supposition that traders provision of services through deployment of their employees to end users in the UK. This, of course, is cast in terms of our making the fair supposition. And then if I invite you to
Sorry, I haven't got this here. Which page are we on?
we are on page 225 in the upper tribunal decision, paragraph 217.
Oh, here we are. Sorry, I found it now. Yes.
So between H and J, we've got HMRC in any event make the fair supposition that the trade was provision of services through deployment of their employees to end users in the UK.
Right.
Yeah, and then if I invite you to cast your eyes down to over the page, paragraph 219, between the letters F and G, you see that it doesn't seem to be controversial for the tribunal. So the nature of the tribunal's trade was supplying contractors, such as Mr. Hoey, to end users.
And in order to do that, you obviously have to pay the employees the amounts which the whole scheme is set up to protect and to enable them to get in their pockets at the end of the day.
And indeed, the tribunal said its purposes included remunerating and rewarding.
Yes.
Absolutely, and this is the point to which I wanted to take you, which is that there is no shortcut for remuneration. Remuneration, and I'll show you through a series of cases. Remuneration is simply a species of expenditure, and in order to get a deduction for it, it must be wholly and exclusively for the purposes of trade.
Yeah.
The reasoning given for why expenditure can be said to be for the purposes of the trade focuses on, and I'll take you to McKinley in a moment, focuses on whether or not it's necessary, whether it is needed in order to secure the loyal service of personnel or to incentivize them in order so that they carry on working, because that is obviously going to redound to the benefit of the trader.
But if your trade is providing the services of the contractors, you've got to pay for that service. That's what the remuneration reflects. And it must be wholly and exclusively for the purposes of that trade then, unless there's some other ulterior purpose.
Exactly, my lady, and that is the point, that you may pay remuneration, but you still need to be paying it only for the purposes of your own trading activity. It mustn't be for any other purpose, such as seeking to facilitate a tax saving for your employee. Unless, and this is the unless you can show that facilitating the tax saving for the employee is for the purposes of your trade.
But that may just be an effect of it. The employee is worth 100. He's providing his services and he's worth 100. The employer pays 100. Whether the employee receives 80 or 60, depending on how tax efficiently the payment is structured, is neither here nor there so far as the employer's purpose is concerned. There may be some added benefit to the way in which the employee receives it, but it doesn't alter the purpose, does it?
My lady, if I may, can I perhaps put it like this? You may well be right when it comes to ordinary everyday trades. Somebody provides, so you have an agency that has people on its books, say they are employed by the agency and it provides those services. In an ordinary course, that might be the analysis that follows, because there is no other reason. Now, here we have an elaborate scheme where, and I'll take you to the evidence, where not only is no profit earned by the employer from the provision of their services, no profit and this is a finding of the judge, that income minus what he pays out as the receipts minus what he pays out gives a net sum of nil. Where you've got a statement in Mr. Parr's witness statement that Hamilton Trust, which was the employer, not the EBT, did not seek to retain any profits. It intended to earn no profits, and I'll take you to that. So in circumstances where the employer is earning no profits out of the enterprise, in circumstances where the employee, and certainly Mr. Hoey gave evidence, that he was the one who secured the services that he was providing to people. So it wasn't his employer who was the person finding an end client. The question of incentivization or to secure the loyalty of this person in order to carry out that activity doesn't arise, because Mr. Hoey is the one who has sought these people out and is providing those services to him. And the third feature of these arrangements, we say, which puts it not in the same category as ordinary everyday employments, is that it is all part of the engineered structuring of these arrangements. In circumstances where Penfolds, as the employer, and Hamilton Trust thereafter, get in the fee income, pay out that amount, they don't have any part to play apart from doing those two things. They don't secure the contracts with the end users. And
Why does that matter?
Because and I take you back to the point, which is that in order for remuneration to be regarded as a deductible expense, it is characterized as being something that you need to pay to an employee to secure their services, to secure their loyalty. And we say that
unless it's just pure consideration for their services, why isn't that enough? If it's consideration for their services, you don't need loyalty and all the rest of it.
Well, the feature that we say taints this is because the purpose, and not just the effect, and I'll take you to why I say that because of McKinley and Arthur Young, the purpose of these arrangements was to ensure the private benefit for the employee in circumstances where the employer got no benefit out of it. Nothing redounded to their advantage out of these arrangements.
They must be making,
because the profits arose elsewhere.
Must be making fees along the line somewhere. Otherwise, why would they do it?
Well, we tried to bottom this out, and I'll take you to the bits of evidence that show this. But profits arose somewhere else. The fees and the intermediaries seem to arise. Mr. Parr gives evidence, and I'll take you to that there was no connection between the offshore employer Hamilton Trust and any of the intermediaries. We've seen, so there was profit somewhere, but it wasn't in the offshore employers. And so in those circumstances, we say that these arrangements fall out with the normal range of arrangements where people do work and are paid a salary.
Have we got the contract of employment in
No,
documents? I'd like to see.
We tried, my lord, and we didn't get it to the FTT, and we haven't had it since. If I could take you to, let me take you to the evidence. Before I take you to the evidence, might I just run through a few of the case law principles?
Forgive me, just what you're saying is the employer is just an SPV, which is held, presumably owned or structured, so it isn't actually effectively carrying on any real business. Is what you're saying?
Well, we've accepted that they carry on a trade, so we can't say that they're carrying on no business. What we're saying is, and we don't know what the rest of the group structure is like, but we know that the intermediaries, because of Mr. Parr, the intermediaries were not connected with the offshore employers, and the finding that there was no profit that stuck in the offshore employers. So all that came in was paid out. That's if I could show you that.
Okay, sorry, just before you go there, and it seems to me it's quite important to accept that there was a trade, because, as I'm sure you know, in tax law, there is a principle that a trade can be so tainted or, as it were, embroiled in tax avoidance that it can't be treated as a trade at all. That's the Lupton. Exactly. And that surely is the relevant principle here. I mean, if you have a trade which is completely denatured, then there's existing case law which says you can effectively say at all, but we're not in that territory.
We aren't in that territory. We're not.
And if we're not in that territory, the mere fact that payments are made with a tax avoidance motive, whether for the payer or for the payee or to facilitate a perfectly lawful tax avoidance scheme, is surely completely irrelevant.
My lord, that's not the way the case law works.
Well, you have to persuade me of that.
Absolutely, my lord.
If we look at McKinley, for starters, I mean, that was a case about partners. And if you look at what Lord Oliver says about employees, it's completely against you as far as I can see.
Well, the bit about the employees, it wasn't a point that he had to consider in any particular detail because he was concerned with partners. But what he does, and perhaps we could go first to McKinley.
Well, so I don't want to take out of your course. I mean, I know McKinley is the mainstay of your argument at the moment. seems to me it doesn't really help you.
Well, my lord, again, I'm very grateful for the indication. At least I know which windmills at which I need to tilt, and hopefully I will succeed in some way, unlike Mr. Cervantes' hero. But let's take a look at, let's go to McKinley, shall we?
Okay.
So the point to make before I do that is that the meaning of serving the purpose for the purpose of the trade has been discussed in many cases, and the definition is the one that one of the meanings given to it is the one from Strong and Woodfield, which is for the purposes of earning profits. And that, if I could just do that with you, first bundle of authorities.
You mentioned a case there, but I couldn't catch the name of it.
Sorry,
Strong and
it is Strong and Woodfield. It's the first bundle of authorities. So tab 6 is Strong and Woodfield. Sorry, tab 1, forgive me. Tab 1, and it's on page 6. Thank you. And it was a brewery company owned an inn, carried on by a manager, customer sleeping in the inn was injured, that was recovered damages, costs against the company, was that a deduction? And it was held that the costs and damages could not be deducted in estimating the balance of the profits for the purpose of income tax, the loss not being connected with or arising out of the trade. And it's really for page 6, if I could take you to that. If I could invite you to read from It Has Been Argued to the bottom of that paragraph, my lords and my ladies. So that's where I get it must be made for the purpose of earning the profits. If I might continue, the next thing is to consider the next principle, which is how is it one determines what is the purpose of the payer, and that requires one to look very carefully at the reasons for which the payments are made. Now we obviously have Malilou and Drummond well in mind, which is the case of the barrister's clothing. It's not actually in the bundle, but in that case, a barrister's set of clothing was said not to be wholly exclusively incurred for the purposes of the trade, because not only was it something that was necessary in order to come into court and comply with the relevant rules, it was also providing warmth and decency, and that was an unarticulated purpose. Interfish is another of those cases where, if I might take you to it, it's in the bundle of authorities. Tab 25, which is in the first bundle.
If it's tab 25, it will be in the second bundle. In my second bundle.
My first bundle, thank you for that, my lord. My first bundle finishes at 36.
Okay, afraid mine. Never mind.
I see. I can stick with the tabs. So, tab 25. This was a case where expenditure was incurred by a company to support a local rugby club, and the findings below were that there were two purposes. One of those purposes was not for the purpose of the taxpayer's trade. One of them was to support the rugby club. The other was, by supporting the rugby club would think better of them, and therefore their business might improve. And it was held that that second purpose tainted the payment. So, Lord Justice Moses, this was a case in which it was argued that if there is a purpose and it's a secondary purpose or an intermediate purpose, it's subordinate to the primary purpose and shouldn't count. And the courts came down very hard on that and said, no, it's wholly and exclusively, which means any non-trade purpose. And we mean that as strong and Woodfield non-trade, which is any purpose that doesn't earn profits for the company that is making the payment.
Well, sorry, going back to Strong and Woodfield, and it just says for the purposes of carrying on the trade and earning profits from it. It doesn't necessarily have to be aimed at making profits. You would have a trade carried on for a hobby.
And we would say that and earning profits is it's a cumulative requirement for carrying on.
Well,
the trade
I'm just
and
guessing that can't be right, because otherwise it would rule out the various types of trade which are not carried on for a profit, which are nevertheless trades.
It's for the purposes of the trade doesn't undermine the existence of the trade, my lord. I would say to that. It is accepted. I mean, ICLR makes it quite clear that case. The Incorporated Council of Law Reporting makes it clear you don't have to have a trade profit purpose in order to be carrying on a trade. So we're not saying that, but there is a trade. But for the purposes of the trade, Strong and Woodfield tells us it needs to be for the purposes of earning profits.
Well, it can't be right if a trade doesn't, by definition, have to be one that makes a profit. I mean, that's why when that's an additional requirement, it's stated in the legislation. You get the additional requirement with a view to profit. And that comes up in lots of contexts.
That isn't a relevant concept in this.
Well, precisely. So since it's not imported into this context, it can't follow that the trade has to be one which is carried on with a view to profit.
My lord, I would say that isn't the way that case law approaches this point, and certainly not the way in which.
Well, it seems to me the case law is looking at something quite different, or at least, I mean, it's looking at purpose, but it seems to me you have to distinguish between purpose and motive. I mean, the purpose is what you seek to achieve by making the relevant expenditure, and the motive is the reason why you're doing it in terms of your ultimate end in view. And nobody, to my knowledge, has ever suggested that just having a tax avoidance purpose is enough to make trading expenditure dual purpose.
Well, my lord, Scots Atlantic, we would say.
Well, that's quite different. That was artificial inflation. I mean, that was just a comically inept attempt to, to pluck a figure out of the sky, which bore no relation whatever to the non-existent services which were carried on by the members of the taxpayer's family. And it was
and strategic branding, my lord.
It was a good try.
And Bly groundworks. And I mean, there are stacks of cases that, and I was going to take you through quite a few.
All right, we'll have to go through the stacks in that case. But can I suppose for these purposes, let us hypothesize a trade which is aimed at facilitating and carrying on lawful forms of tax avoidance. And that's a perfectly legal trade. And indeed, illegal trades are taxed, aren't they? I mean, we all know.
We all know about that.
Yes.
Yes, my lord. But what we would say, my lord, is this: that you can have a trade which doesn't seek to make a profit and doesn't make profits. But we would say, if something is sought to be a deduction, it must be wholly and exclusively for the purpose of the trade. So you need to be able to show in what way it is assisting the trade. One obvious way of showing that it assists the trade is that it earns profits from it. If there is nothing else that redounds to its benefit as a result of carrying out these activities, we would say it is very difficult to cast it in terms of advancing the trade or for the purposes of the trade.
Well, with respect, I don't understand that, because as my lady has put to you, I mean, the obvious purpose of these payments was to provide Mr. Hoey with his remuneration at the rate which the whole scheme started, whatever it was, £500 a day. I mean, that had to get, he wouldn't have signed up to this scheme unless he knew he was going to get his 500 quid. And that had to be achieved.
Well, my lord, may I take you through the principles first and then take you to the facts? And then
all right, and the principles, they're pretty well established. I know you're going to want to take us through them, but I'm not altogether sure we're going to get a huge amount of enlightenment from looking at the cases rather than the facts.
Okay, well, let's look at the facts.
Well, all right. I don't want to take you out of your course. So if we need to look at the authorities next, and we do certainly at some point need to have a look at McKinley.
Absolutely. Why don't we go to McKinley next, which is at tab 10
9.
of the first bundle of authorities.
I think it's 9.
Tab 9. And that, of course, is, as my lords and my lady will know, was a case of accountancy partners who were relocated within the country for the benefit of the enterprise of the partnership. And in order to make it palatable and to remove the disadvantages of having to relocate, sums were paid, such as relocation expenses and the like, in order to incentivize them to do this thing. And it was held that those sums were not wholly and exclusively incurred. If I could take you to page 251, internal report of the report, page 165 of the bundle. So there was a confusion in the Commissioner's minds below about the difference between an entity and an employment and the like, and that's the point that my lord picked up earlier. Between D and D, there's a sentence: the real, indeed the only question in this appeal is whether that was a permissible way in which to test whether the expenditure was laid out not merely as something from which the partnership was intended to and did derive a benefit, but exclusively for the purposes of the partnership practice. The appellant, having appealed to the High Court, Mr. Justin Vineland, in a judgment of admirable clarity, reversed the Special Commissioners and allowed the appeal. It was not, he observed, seriously open to question that if Mr. Wilson and Mr. Cooper had each been sole traders, if such a description is permissible in the case of chartered accountants, and had moved their respective residences in order to enhance the interests of their respective professional practices, the expenditure incurred in finding a new home and moving to it could not qualify as expenditure incurred solely for the purposes of the practices, so as to permit its deduction in the computation of their professional profits as sole traders. In searching for and acquiring and moving to new residences, whatever their motive, they could not possibly be said to be acting as accountants in the course of professional practice. They would be simply individual citizens establishing private residences in places convenient to them. And as Mr. Justice Vineland observed, the expenditure would be indistinguishable from that incurred by Mr. Mason and Mason and Innes. In order to, so just skipping forward a couple of lines, in order to justify treating the expenditure by an individual partner on a different footing, it was necessary, in effect, to ignore any benefit deriving from the original outlay made by him as an individual, and to treat as the relevant purpose only the motive of the Executive Committee in making the reimbursement, i.e. creating some sort of distinction out between the two, from which, of course, the firm as such derived no benefit beyond that of securing the performance of the individual partner's services in the most convenient area. That's where I picked up the securing services language. Thus, the respondent's case rested before your lordships upon the proposition that in its relationship to individual partners, the firm can be treated as a separate legal entity in exactly the same way as if the relationship were that of an employer and employee. And indeed, it seems to have been the basis of the judgment in the Court of Appeal which reversed Mr. Justice Weinbach. Then he goes through Eastie and Beach. If I might then invite you to go over the page to bundle page 168, internal page 254, report page 254. And if I could ask you to cast your eyes down to the paragraph that starts with finally. Confusion caused in the Court of Appeal, as indeed it was before your lordships, by an appeal to the position of an employee as providing a useful analogy. Superficially, the analogy is attractive, as indeed is the suggestion that the reality of the situation renders absurd any distinction between, for instance, a senior employee and a junior partner. But with respect, the distinction is not only legal, but real. An employee has no interest in the property or profits of the firm, and anything paid to him by way of additional remuneration for acting as an employee and to secure his continued loyalty to the firm cannot easily fail to be deductible as an expenditure exclusively for the purposes of the firm's business. There are, of course, limits to this, and we invite you to consider that, my lords and my lady. There are, of course, limits to this. For instance, the firm cannot pay the employee's PAYE tax for him and claim to deduct it as an expense, and that's Bamford. That's sort of that chimes back to section 222 in a way about the payments. And what we would say is actually what's seen here is that the relieving the employee of a tax liability is not a deductible expense. That's what that exception is saying. And we say, by analogy, facilitating relief from tax, such as PAYE, income tax on earnings, falls into that category. It's a relief from tax.
That's a particular payment, which is discharging a tax liability, whereas here we have just a payment of remuneration in a particular form, namely in the form of loans. Why does that not fall within the principle which Lord Oliver has stated between F and G in the sentence beginning, an employee has no interest in the property, and so forth. And then as he goes on to say in the next sentence, but in general, money laid out in order to secure the continued loyal service is referable solely to the business or profession in which that workforce is employed and is accordingly deductible.
And we say, my lord, there are two reasons why this passage, we say, clarifies for us what we need to prove to you, and which we say our facts do prove, and I'll take you to the facts now. One is that a relief from tax, and you've cast it in terms of an actual payment to relieve the tax. We say it's relieving the taxpayer of a burden of paying that tax himself. So it's taking on a burden that would otherwise be the employee's burden, and thereby relieving him of it. And that is therefore something that has been identified as a non-deductible, even in this example.
But is it? Everybody understood at that stage that the scheme worked, and if they paid it in this very efficient way, there wouldn't be any tax.
Well, at least there would be tax, but only under the
benefit of the loan benefit. But there wouldn't be the ordinary employment income tax.
And I'm going to take you to the facts. The Probis promotional material talks about 80% of your income coming home to you.
So instead of only getting, let's say, 60% for the sake of argument, he's going to get 80%. But that's because it's been structured as a payment into an EBT and out as a loan, not because the employer is discharging a potential tax liability.
The analogy we're seeking to draw is the relief of a tax burden from the employee.
But it's not a relief of a tax burden. They all proceeded on the basis that there was no tax burden.
Well, my lady, if they had paid the amount directly to the employee, all of it would have been subject to PAYE, instead of which they put it through this. The question to ask yourself and ask oneself is, what is it that prompted that change of route? And the change of route, we say, was the avoidance. It was to facilitate the avoidance of the employee in order that the employee could take home more of the money that came in as a result of their services.
But the whole amount was consideration for his services, and how much tax he had to pay on it was a matter of arrangement as between the employee, perhaps the employer, to the extent that the employer was prepared to pay it into an EBT, and the revenue. But that's just the effect. The purpose was to reward him for his services.
The reason we make a point of this, my lady, is because, and we maintain this position, that the trade is not benefiting, is not profiting from these arrangements. All it is doing is entering into a series of contracts, but gets no financial.
Well, in principle, it must be profiting somehow. I mean, it's not a charity. We know it must, in one way or another, have been getting fee income or some kind of a cut, or
there
in
is
return.
No evidence of that,
Well,
my lord.
it just must have been. It's make nonsense otherwise.
Well, my lord, so if I take you to for instance, Mr. Parr, this is in the statutory supplemental bundle, to tab 20.
Sorry, which bundle?
Supplemental statutory appeal bundle. So Mr. Parr gave evidence, and I'll draw a bit of his evidence now as well. But in his written statement, he is. They were approached by Kingston Smith to be the Hamilton Trust. Although it's a trust, it's actually the employer. There's a separate EBT, which he also describes.
Sorry, do we have his witness statement?
Yes, it is, my lord. It's behind tab 21 of that bundle.
Yes, thank you.
And so his role in this is set out the managing director of Hansard and have been with the company. So paragraph 1, and then where the fact I'm a chartered accountant, and then over the page, various stints at various companies in Guernsey in '99, where I worked as a client account manager for a particular company. Then I joined Hansard. In 2009, Hansard was approached by Kingston Smith, who are accountants, and asked to provide trustee and offshore services to a new trust, Hamilton Trust. I accepted the role of individual trustee together with trustee Bruce Naught. And then he went down contractors, paragraph 6. Contractors, such as the appellants, would enter into a contract employment with Hamilton Trust, and under the terms of that contract would be paid a salary of about 15,000 to 18,000 per annum. The trustees were required to meet strict compliance requirements, know your client, and I'll take you to that and the dissonance between that and the evidence actually given in cross-examination. Hamilton Trust entered into contracts with various intermediary companies, such as Cascade, with a view to providing the services of the contractors to third-party end users. The intermediary was responsible for arranging placement of the contractor with the third party in each case. And you will see from the evidence, and I'll just take you to that as well, Mr. Hoey dealt with the intermediaries, not really with the employers.
And the intermediaries received a fee for doing that.
Yes, my lady.
Yes.
And what he says, there is a point he makes about those companies not being connected. Hamilton are billed for the services using outsourcing contractors. The trust would be billed for making fee payments to the intermediaries and others for services they provided to the trust. And then further down, to engage, so the Hamilton Trust was a purpose trust. The purposes of the trust were as follows, and I ask you to cast your eyes down to the 4th bullet.
Well, that's about retention of profits. Doesn't necessarily mean they don't make any.
And then that is, then we look at 11, the responsibilities of the enforcer include ensuring that the trust operates in accordance with, and then we come to then could I, they then set out at paragraph 20 what they can do, and they ceased trading in 2011. Number of loans were waived.
Sorry, where do we?
I'm over page 148, paragraph 25. And my learner junior reminds me. And if I could invite you just to turn to the next tab, which is Mr. Hall's evidence, which is at page 150 of the bundle.
He's a tax advisor.
He is the tax advisor. And about halfway down to paragraph 6, between the two hole punches, the intermediaries, broadly speaking, arrangements very similar. Individuals were introduced to the arrangements by UK-based intermediaries who were unconnected to the non-resident company or trust. So the intermediaries we understood to be unconnected. So if the fees arose to them, and the point was that that was how the scheme was structured, the arrangements were structured, that the fees would arise to these unconnected intermediaries.
But fees charged to the end client would be paid via the employment agencies and intermediaries to the company.
Yes, and then
Trust.
the fees charged would be, and then the company trust would pay a salary to the employee. Thereafter, payment out of the profits of the company would be paid to an EBT, which could then offer loans to the individual employees, which would be repayable on demand. And if you go now to the FTT decision, which is to be found in the core bundle, tab 17. around paragraph 162, which is to be found at page 22. Let's start at 21.
322 is the page.
Yes. Paragraph 162 to 322. Thank you, my lord. So, measurement of the person. It was agreed between the parties that income for these purposes was profits of the person abroad. They have given no evidence of the profits by the Penfold or Hamilton, such as profits and loss accounts. The evidence I was given suggests that the profit and loss account of Penfold Hamilton consisted of the receipt of fees from the intermediary in respect of Mr. Hoey's services, which, according to the agreed statement of common facts, and I'll come back to that, were received from DMS Cascade net of fees payable to the promoters and other facilitators, less the payments of salary to the contractors and the funds contributed to the trusts. And then he records my suggestion. And then at 165 he says, from the information I have, therefore, the profit and loss account of Penfold Hamilton consists of net fees received from DMS Cascade, less the salaries and the payments to the trust. There may have been a small amount of residual profit remaining in Penfold Hamilton, but I have no evidence as to the existence or amount. And then he carries on in 166, in arriving at Penfold Hamilton, I think it is not in dispute the amounts paid by way of salaries to contractors are valid deductions. Payments to the trust are, however, potentially more controversial than in the court is finding. Then at 168, he talks about the income, and at 169, he finds that the income of Penfold and Hamilton for these purposes was nil. So when you take account of what came in, net of intermediaries' fees, and what was paid out, the profits that stuck in the employer were nil. And we say that is highly relevant, especially when you put it together with the fact that the arrangements were designed for the profits not to be retained, for nothing to be retained. And I note your linguistic point, my lord, that they're talking about not retaining profits as opposed to not earning profits. But here, if one looks at income less expenditure, and you find that the answer is nil, the answer, we would say, to that linguistic point is also the same, which is that there are no profits.
But wouldn't this might be relevant if you were saying there wasn't a trade,
Yes,
but
right.
you've accepted it's a trade. So I don't understand why it matters.
My lady, because it shows that the end employer was not benefiting in any material way from this.
But as my lord put to you earlier, there's no need for a trade can be continued for a hobby. You don't need to benefit financially from a trade for it to be a trade.
My lady,
do you?
I agree that you can carry on a trade without earning profits.
Yes.
But I think the case law suggests, Phillips and the like, and my Lord Henderson's recommended, Lord Justice.
Well, excuse me, that was an entirely different point.
It wasn't a trade.
It wasn't a trade. That was the whole point.
Yes, but the point I was making was that a hobby cannot be a trade. It needs to be carried. A hobby cannot really even be a business. It needs to be something more than a business in order to be a trade. And we say that we are accepting here.
I mean, the hobby farmer is a well-known category of person.
Trader, yes.
A trader. I mean, it is a trade. It's just one which is not carried on with a view to profit. That's why, in many contexts, including film scheme contexts, you have to satisfy the additional requirement of it being a trade which is carried on with a view to profit.
My lord, what we would say is that, as you rightly pointed out, this is not a charity. There's
No.
nothing to suggest it's
Well,
a charity.
it is something called a purpose, whatever it is. I mean,
Purpose trust. Yes.
I don't know anything about Guernsey Place of Purpose Trust, or is it the Isle of Man? Sorry, I forget which is which, but and that may have something to do with the way it's set up and whether it's allowed to make and keep profits. I know not. But
And the point we're making, my lord, is where the arrangements are themselves designed to ensure that profits arise elsewhere, then the purpose is that the profits will arise elsewhere and not in the enterprise. And we say that that shows.
But so what, if I may put it in those rather unpolite form?
Well, I'm grateful for the clarity.
Uh.
What we say is that the fact that there was no financial gain to this to the SPV, to Penfold's, the offshore employer, or to Hamilton Trust, indicates that that it was not for their trade that this was being carried on. It was in order to facilitate the saving, the tax saving on the part of the employee. And we say that that falls into the same species of category as if you provide home relocation expenses for McKinley, because what you're doing there is not advantaging the company in any way, but is removing a disadvantage to the employee.
Yeah, but excuse me, McKinley was not a case about employees. That's the whole point. It was a case about sole traders, or at least rather traders who joined together in a partnership. But the correct analogy was with a sole trader, and that was what Mr. Justice Launcelot had so clearly pointed out in the first instance. If you're a sole trader and you move house in order to position you better for the purposes of your trade, I mean, that can't be said to be wholly and exclusively for your trading purposes. But that's an entirely different proposition from when you're paying an employee his contractual entitlement. And that surely is, you're then within the, it seems to me, the reasoning of Lord Oliver in the passage where he says it's tempting but wrong to seek to draw an equivalence between the position of sole traders and employees.
My lord, the test is wholly and exclusively. If there is even a purpose,
but that
if there is even a purpose that is not for the purposes of the trade, that is sufficient to taint it.
I know.
What the argument we are putting is, even if it is remuneration, the way it was paid, which didn't, and we say didn't materially, and that is a relevant consideration, because when you look at the cases such as Scottish Atlantic, when they talk about, it doesn't matter which way you pay it, as long as it's exclusively for your benefit. And we say, here it isn't exclusively for their benefit, because there is no benefit to this enterprise. It's there, it's carrying on this activity, but it doesn't have any profits that stick in it. We don't know where the profits arise, but they don't stick with it. The only thing that it is there to do is to be there to receive these fee incomes, to be the employer, to pay the fee income to the EBTs, which are then paid out.
But if it doesn't pay these sums, it can't carry out its purpose. And its purpose was set out in the statement you showed us, and that's its trade. It has to do this to trade in accordance with its purpose.
The purpose is to provide the services. That's what the FTT found, and the UT was happy. Well, that's what the UT said the FTT found, and we're content to go with it, providing the services of the employees to end users. We say that in this case, it is highly relevant that these arrangements presupposed and were intended to achieve one outcome, and that outcome was the 80% take-home pay at the back for Mr. Hoey at the end of these arrangements. That was facilitated by the entry into these arrangements by Penfolds as the enterprise that would be his employer and provide his services through a series of contracts. My learned friend took you through the series of contracts. Well, took you through what we suppose is the series of contracts to the end user. In those circumstances, to cast the entirety of the disbursement to the EBT as remuneration simpliciter and without any additional purpose, we would say is not taking a realistic view of these facts.
Well, what you're doing is you're looking at the purpose, the purpose of the overall scheme as marketed to contractors, and you're then saying, well, because that's the overall scheme, a component of that, namely the remuneration paid to the contractor for their services, has to be looked at in the light of that overall purpose.
And my lord, we have authority for that at Scots Atlantic at paragraphs 80 and 81 in the other tribunal. If I could just take you to it, and then I'll carry on with the factual analysis. So Scots Atlantic. Is at tab 29 of the bundle of authorities. in effect, the aim of these arrangements, I can cut a long story short, the aim of these arrangements was to achieve a sidestepping of Schedule 24, which brought in a timing difference for deductions. These arrangements were entered into in order to facilitate that. So there was an EBT involved, there was a payment to the EBT. And the question was, at what point did the deduction arise? And in looking at whether or not the payments to the EBT were a deductible expense, if I might just invite you to go to paragraphs 80 and 81 of the decision, which is on the last page, report page 1340, bundle page 742. The point we draw to your attention is that when payments are made in the context of arrangements, it would be, although you look to see what is the purpose for making the payment, you don't divorce it from the factual context in which that payment is made. And here we say the factual context is, I know my Lord Henderson may disagree, but these are structured arrangements. They were sold on the basis that they were structured arrangements. The payment from the employer, Penfolds or Hamilton Trust, was part of those arrangements. They were an integral feature of the facilitating of the 80% take-home pay for the individual contractor. We say, therefore, that at least in looking at the motivation, the purpose of these arrangements, it was not just the effect, it was in order to make this happen, i.e. the 80% take-home pay, that the payments had to be made as to the EBT, so that they could be made as loans to Mr. Hoey. That is the point. And so therefore it is a cannot but be. It is not merely that it's an effect. It was very much a part of these arrangements. And Penfolds and Hamilton were a part, an integral part of these arrangements. And so their purpose, even if one says that this, if one accepts that this is remuneration, their purpose was in order to ensure the remuneration bore the least amount of tax in Mr. Hoey's hands, and that was done by way of paying the payments to the EBT. So it's a cannot but, we would say. It is not merely a side effect, it was the purpose.
And I suppose you would then go on to say the FTT erred in law in failing to appreciate that inevitable analysis.
Well,
is that right? Because the fact is that at the moment you have a finding of fact did against you, of course, by the fact-finding tribunal, which is the complete opposite of the situation in Scots and the other case you were showing us recently.
Absolutely, my lord. And I skipped over the relevant paragraph when we were looking at the FTT decision. What they didn't do is ask themselves the right question. They stopped at saying it's salary, it's remuneration. There's no distinction between the small amount and the big amount, not asking themselves why we weren't making the same argument in relation to the small amount and the big amount. But they said, because it's salary, that is, therefore, must be deductible. And we say that is the wrong question of law. It must serve the purposes of the trade. It must, we say, and I recognise the criticism coming from the bench, that it must, we say, be for the purposes of earning profits.
And presumably the FTT were referred to the leading cases on deductibility and so forth, so it's not as though they were uneducated, of course they wouldn't be. Could possibly be with the benefit of your submissions and those of Mr.
I'll take the compliment, my lord. The point is
those
that,
of Mr. Mullen, but yes.
so they were taken to all the authorities. Of course, there have been some authorities since, but they were certainly taken to Scots Atlantic.
Well, in that case,
Certainly.
we need to read their ultimate decision. I know it's quite briefly expressed, but I think on the supposition that unless they've really made it quite clear that we have to assume they got the law right. And on that view, it seems to me at the moment a perfectly tenable position which they took, which was, to paraphrase, the facts are a complete, well, really very incomplete, and we've had rather unsatisfactory evidence, and we can't begin to work out exactly what happened and how to draw up a full profit and loss account. But we can say nobody has disputed the deductibility of the PAYE part of the remuneration, and as to the rest, we think it ought to be treated on the same basis, because that was how Mr. Hoey got his agreed pay
Just on that
in
small
his
PAYE
pocket.
portion.
The taxability of all that is another matter.
So I'll take you to exactly what they say in a moment. Paragraph tab 17, full bundle. In terms of the distinction between the small amount and the big amount, the small amount actually did have income tax. PAYE was returned in relation to it, so there wasn't any tax saving. So it wasn't a point in dispute in the tribunal. So there was no reason to raise it as an issue for the tribunal. So to draw an analogy between the fact that the revenue didn't dispute the deductibility of that payment with something that was disguised in respect of which no PAYE was being operated.
But on your argument, on your analysis, that part shouldn't be deducted either.
My lord, if the argument was put as instructed, there was a distinction made between the small amount.
No, what I asked you was on if one applies your analysis,
Yes,
it shouldn't be deducted.
it should all be tainted by the same tax avoidance purpose.
Well, and you say none of it is for the purpose of making a profit. And indeed, if they subsequently turn around and said, hands up, we realise now in the light of the Rangers case that we made a mistake, and we're going to pay up on all of it, you'd still say, even if they voluntarily paid the notional deductions, you'd still say that they were liable under TOAA.
There is no, yes, my lord, you're right, we would still make the same argument because there is no direct relationship between taxability and deductibility. It doesn't have to be taxable in somebody's hands in order for it to be deductible. I do have authority for that. The name of it is slipping my mind right at this moment. But there is no direct.
Can I ask you this? If a perfectly legitimate trading company, whether or not profitable, possibly with a ulterior motive and possibly improperly, agrees to pay various people providing services to it in cash, thereby paying less than they might otherwise have to pay, would those sums be deductible?
I'd like to quote what my learned friend said, but I'm not
Sufficient unto the day is the evil thereof.
That's the
I
one.
don't know where I got that from, but it sounds good.
Sounds biblical, actually.
Those sums are paid wholly and exclusively for the business, aren't they?
My lord, what I would say is it is so fact specific, and that is why I wanted to take you through all the cases. You would have to know why it was they were paying it in that way.
Well, because they know that the recipient is not going to declare it for tax, so they are therefore paying less than they might otherwise have to pay.
And how would that, if I might just press the factual point a bit further, how might that be for the purposes of the payer's trade? Because it's in order to get the deduction, it needs to be wholly and exclusively for the purposes of the payer's trade. So
they need that work done, and they have to pay for it. And this way, they pay less than they would otherwise have to pay for it. They would have had to pay £100, but this trader is willing to do it for 80 because they are receiving the money in cash.
And the sort of work you're talking about, if I might just ask, because there are questions about capital and revenue, there are questions of wholly and exclusively.
This is a business that needs to have one of the tools of its trade mended, and it gets a a contractor to come in to mend it, and the contractor says you can pay me £100 by bank transfer, or you can slip me £70 under the table.
My
I'm
lord,
not
beguiling
under the table.
as
You
this
can pay me in
invitation
you can pay me
is,
in cash.
beguiling as this invitation is, I'm afraid I'm going to have to resist the temptation of answering it, because what I would like to press home to you is, in these circumstances, in this case, we have arrangements whereby they were designed to have nothing, no profits arising in the relevant entity. And we say there was no benefit to this entity. There was no reason why they took part. And that was an integral part of these arrangements. If those, and in those circumstances, where the only reason they seem to have taken part in this is in order to facilitate profits arising elsewhere and profits and tax saving for the individual, those are not for the purposes of their trade. Whatever may be the other purposes, those two purposes, we say, deny the deduction in this case.
So if the employer had earned some profit, there'd been fees retained as a result of this arrangement, that would have made all the difference.
It wouldn't have made all the difference, but because we would still have to inquire into what it was they were seeking to do. But if it was the same factual enterprise, we would say that the fact that the arrangements were designed in order for the profits to arise to other people as well, who were not itself.
But why does that matter?
Because it's not for the purposes of their trade. It's the same, it's the interfish point, which is that if you have two purposes and one of them is not for the purposes of your trade, you don't get the deduction. So all the purposes must be trade purposes, and all of them must be for the purposes of your own trade. And Vodafone Cellular and Shaw is a case where...
forgive me, I really don't understand that the purpose of the offshore company's trade is to, well, you say that, and you accept that it's to provide services to end users. Well, that's definitely fulfilled. You're looking at some broader purpose, which is to facilitate a tax avoidance scheme. That's what you're really saying, for the benefit of others.
And for profits to arise to other persons, i.e. the intermediaries, who are not connected on Mr. Hall's evidence.
Well, you may well have subsidiary companies who are operating on a break-even basis, but for the purpose of making profits for their for companies higher up the chain, or maybe lower down the chain. But that doesn't mean that they haven't got legitimate businesses.
Nobody's denying that this is a trade, and we're not denying the legitimacy of the business. What we are saying is that deduction isn't available because there is an additional purpose. And in terms of group companies, Vodafone Cellular and Shaw talks about how that should be...
The additional purpose is to benefit somebody else, but that's the addition that would apply for a subsidiary that's trading for the benefit of its parent company.
And my lord, Vodafone Cellular and Shaw does make the distinction. If the company, which was a holding company, had got rid of the onerous contract for the benefit of other people, which is what was being argued for the subsidiaries as well, that may have been a problem. However, it was held that it was properly viewed. Its purpose was to get rid of the onerous contract for its own purposes, for the purposes of its own trade, because it obviously, to get rid of an onerous contract, benefited its own trade. The fact that it also benefited the subsidiaries was an effect. That's how it was distinguished.
So you're distinguishing between purpose and effect.
Yes, of course, one must always make the distinction. Well, forgive me, my lord. I mean, that was why I wanted to go through the principles.
You accept here that the purpose of the trade is to provide services to end users.
It's not the only purpose. What we're saying, the additional purposes are to ensure that Mr. Hoey receives 80% of his sums, i.e. a freedom from tax to a certain extent, i.e. tax avoidance, which is it redounds to his benefit. It doesn't actually serve the purposes of the payer, because that is a tax avoidance that is enjoyed, as it were, by another person. Ditto, funds, profits being received and earned and kept by persons who are not connected in any way, and i.e. the intermediaries, because providing profits to other persons is clearly not for the purposes of your trade.
But surely, give me purpose of the trusts, the offshore trusts, is fulfilled by making available the tax benefits to the contractors. That's how they acquire people to provide services to the end users. It's part of their business model, their trade model.
Their trade was, and this is a finding, was to supply the services to end users, not to facilitate the avoidance of.
No, well, unless they advertised and did provide this benefit to contractors, they're not going to get them, because nobody's going to go and put their business through an Isle of Man or Guernsey trust and pay fees unless there is some other benefit. so that providing the benefit to the contractor is what makes it attractive for them to sign up, and which then enables them to fulfill their purpose of providing those services to end users.
My lord, you raise a very good point, but I'm slightly conscious of the time. Are we not due a transcriber break?
Do you want to have a break at
Well,
this
no.
point?
I'm perfectly happy to continue. I just wasn't sure if we were at that point yet.
Well, we are at that point, but it would be nice to have an answer to that.
Yes, absolutely. And can I give that to you once
Yes.
we're back from
Yes.
break?
Let's have a 5-minute break. Thank you.
Most importantly, sufficient unto the day is the evil thereof is Matthew chapter 6, verse 34, Sermon on the Mount.
Well, thank you. arise?
My lord, so you had said to me, in effect, that the people wouldn't sign up for this enterprise were it not for the fact it was offering these tax savings. And my point, if I've understood the question correctly, so why is it not for the purposes of trade? And what we would say is, be that as it may, the fact that its purpose was also to ensure that profits arose elsewhere is, we say, that additional non-trade purpose, because it's not serving its trade. And the fact that this is an important point is, we would say, made clear from Vodafone, Cellular and Shaw, because there, even the benefit to a connected subsidiary was sufficient to risk the denial of the deduction. So if I could just take you to Vodafone, it's in the it's in tab 10, which for me is in the first bundle of authorities.
Indeed, that argument persuaded Mr. Justice Jacob at first instance, if I remember rightly. It only came on stuck in the Court of Appeal.
You are of course deeply familiar with this case.
Well, I was at one stage.
So Lord Justice Millett, there was in effect an onerous contract. The onerous company was set up in order to be able to carry on this activity. It needed to have two subsidiaries for regulatory purposes. Those two subsidiaries and a contract was entered into by the parent in order for certain facilities to be provided. Over time, it became apparent that the technical facilities weren't necessary, and it had the contract it needed to get rid of. Getting rid of that contract would benefit the subsidiaries as well. Query whether that was sufficient to taint the payment made to get rid of this onerous contract by the parent. And it was held that if I could take you all the way to paragraph 742, which is where the principles are set out. Page 742, thank you, madam. Page 742, was the payment made wholly and exclusively for the purposes of the taxpayer's company's trade? And can I ask you to read that over the page, just to see? So if I might just pick out a couple of points. The distinction between a parent and its subsidiaries is drawn out from the passage between D and D. And we say that if one still can only focus on the benefit to the taxpayer, or if one can only focus on the purpose of the taxpayer who is seeking deduction, and not even a subsidiary, a fortiori, the fact that profits are being paid elsewhere to persons who are not connected on the evidence of Mr. Hall, must mean that it's not for their purposes. It's not for the purposes of their trade.
I'm sorry, their trade involved the remuneration of their own employees. I mean, that's what they were doing. They were just doing it in a slightly unusual fashion.
Their trade was to provide the services of employees to third parties.
Yes.
Remuneration was something they did as part of the arrangements, and the way in which they did that was in order to achieve the purpose of the arrangements, which was a tax saving for the employee. But the finding of fact is that the trade was not providing the tax advantage to the employee, the trade was providing the services to third parties.
What would your position be if, say, the employer, in order to attract contractors, paid 5 times the going rate? We want the best, and so therefore we're going to pay 5. Everybody knows that it's 100, but we're going to pay you 500. Would that be a private choice of the employee? They're paying more than the going rate, or would that be for the purpose of the trade?
It would, my lady, there's a case called Copeland and Flood, where over the odds were paid, and because they were over the odds, it was said that by the revenue that you can't get a deduction for any of it. The Special Commission said they're not going to interfere with the amounts that are paid to persons as employees, because that's for the companies to decide. It was decided in the High Court, I think it's in tab 2 of your bundle of authorities, it was decided in the High Court that it ought to be remitted to the commissioners to decide whether or not that payment was wholly and exclusively incurred. The fact that it was remuneration didn't stop the inquiry for what it was paid. And the way the facts are set out suggests that actually some part or all of it would have been regarded as non-deductible, because the persons to whom it was being paid were totally unskilled and were children of the director of the company. So for the first point, paying over the odds can cause an inquiry to be raised, and the purpose of for why it is that it is being paid needs to be established. It's a very fact-sensitive inquiry. One needs to look into the minds of the people, and you have now got the principles summarised here in front of you. You have to look into the minds of the payer to decide what it is they're paying for and why it is they're paying this. If it's the market rate that's being paid, then they are getting the best people at the market rate. It would fall into the ordinary circumstances. What we are in is a world away from that. We're in arrangements where Mr. Hoey, in his evidence, accepts he was the one who found the work, not through Penfolds, but through Cascade or through Oldbury Howard, i.e. the recruitment agencies. He was the one who secured the end clients. He was the one who provided the services. The payments, as it were, went through this series of transfers, and then through into the EBT and down to him.
But again, none of that matters if you accept there's a trade. I mean, I understand why that might have caused you to challenge whether the employers were trading, given that Hoey's doing all the work to find the end users. But you didn't challenge that. You accept there's a trade. And if the unique selling point of this employer to attract contractors is to structure the pay in a particular way, I don't understand why that necessarily means that it's not for the purpose of the employer's trade, the salary payment.
Again, as I say, it's really fact specific. In this case, it was structured in this way in order to save tax here for the employee and in order for profits to arise somewhere else. It was not.
Well, what's the basis in the evidence for your assertion that it was to achieve profits elsewhere in the arrangements?
So I took you to paragraph 6 of Mr. Hall's evidence.
It's paragraph 6 of Mr. Hall, is it?
Yes.
Okay.
That shows that
that was where he said.
That's where he said funds were paid to third parties.
Yes. Fees, he said.
Fees were paid to unconnected third parties.
Yes.
When one puts that together with paragraph 10, fourth bullet point of Mr. Parr in relation to Hamilton Trust.
We
and
don't
forget,
retain.
we don't have, yes, paragraph 10, bullet 4 of Hamilton Trust, that they retained no profits, i.e. it's all gone somewhere else. And one recognises that they were the only people, only employer to give evidence. Penfolds gave no evidence. So we don't know what their purpose was, but given that they too were involved in exactly this arrangement, and no distinction has been made as to the operation of those arrangements as between the two of them, the same purpose must exist, which is facilitating the tax avoidance for the employee, and at the same time having the fees paid to intermediaries on the way of the fee income coming from the end user to them. That was a feature of these arrangements, and the fact that these arrangements were structured in this way, we say, shows that that was the purpose of the payer in taking part in these arrangements. It was an integral part. The Penfolds and Hamilton Trust both played an integral part in these arrangements. They facilitated the fees from the intermediaries and the tax savings of the employee. So then the question, and so what we say is, because the tribunal stopped at its remuneration, that's it, it must be deductible, and we get that from their decision at paragraph 1645. I'll take you to it now. They didn't ask themselves what other purposes were there. They just said, well, it's remuneration, therefore it must be deductible. And that isn't sufficient. And I'll take you to Allway in a moment, and strategic branding, which are also cases about remuneration trusts, because there is this view that if you have remuneration, you get the deduction, you don't have to question it. It doesn't matter that it happens as part of arrangements. And we say that that is pushing it too far. If the arrangements are entirely commercial, are not tainted in any way by an avoidance purpose, then a deduction may well be possible. But if they aren't, you have to take account of the circumstances in which they're paid. And we say that also because of NCL, which was a recent Supreme Court decision. I'll take you to that in a moment. But if I could just take you to where the judge's reasoning, it's very light touch, and they stopped, we say. This is he stopped at just saying it's remuneration. So paragraph 165, from the information I have, therefore, the profit and loss account of Hamilton consists of the net fees received from DMS Cascade, less the salaries and the payments to the trust. There may have been a small amount of residual profit remaining in Penfolds Hamilton, but I have no evidence as to its existence or amount. In arriving at the profits of Penfolds Hamilton, I think it is not in dispute that the amounts paid by way of salary to the contractors are valid deductions. The payments into the trust are, however, potentially more controversial. I must therefore look to the judgment of Lord Hodge and RFC. In RFC, Lord Hodge said, Parliament, in enacting legislation for the taxation of emoluments or earnings from emolument, has sought tax remuneration paid in money or money's worth. No persuasive rationale has been advanced for excluding from the scope of this tax charge remuneration in the form of money which the employee agrees should be paid to a third party, or where he arranges or acquiesces in a transaction to that effect. It is clear from these words that the payments made into the trusts were nothing more or less than additional payments of salary. They therefore fell properly to be deducted in arriving at the income of Penfolds and Hamilton for the purposes of section 71. I therefore find the income of Penfolds Hamilton to be nil. 2 points there. There's the jumping from RFC to saying because it's remuneration, it's therefore deductible.
Well, another way of looking at it would be they understand the law, we can assume, because you told them what the law was. They were alive, weren't they? And I can't remember exactly where, to the fact that there was this inserted stage into the scheme with offshore employers, and that they regarded as
as an avoidance purpose.
So
That's
they were
153.
well aware of it. Sorry, which
I
paragraph?
think it's, let me find it for you.
It doesn't matter.
Yeah.
They were well aware of that purpose. And so although they moved from ranges, aren't they making a finding of fact that what was being paid to into the EBT and then onwards to Mr. Hoey was nothing more or less than salary? That's implicit in that is, although we know there was an avoidance purpose, this wasn't for the purpose of of avoidance, this was a payment of salary.
My lady, that is, we would say that that isn't what one would take from 168. The reference to Lord Hodge, the reference to salary, clear words, i.e. don't ask any other questions. You don't ask, is there another reason for this? And he didn't ask that. As my learned friend Skrzynski points out, sometimes tribunals get things wrong even if one explains it very carefully to them. So they looked at additional payments of salary.
Is that inter orem?
Tribunals, not courts.
They therefore properly fell to be deducted. And it's the therefore, it's the bang, bang, bang. And it reflects the way in which my learned friend, Mr. Mullen, put it in the tribunals below. And maybe it makes sense to show you that at this stage, so that you can see how this finding reflects the way in which it was put by Mr. Mullen below. So if I could take you to yes, if I could take you to paragraph 59.2 of Mr. Hoey's statement of case. So that is to be found in the statutory bundle. So if I could just invite you to put the core bundle away for a moment. So it's a supplemental statutory bundle. It's tab 10, it's page, so this is the appellant statement of case. I invite you to note the date, 27th April 2017, which is on the last page of page 98. The paragraph is paragraph 59.2, which is to be found at page 97. So this is the entire section of contract assets, and in it, at 59, the appellant further contends that no income accrues to either Penfolds EBT or the Hamilton EBT. This would be in the context of those possibly being regarded as the persons abroad to whom income accrues. And then 59.2, such income as does accrue to the employers is subject to deduction for proper expenses of the employer's business. That requires payments to the EBTs, which were wholly and exclusively for the employee's trade, to be taken into account. See Lord Chetwood. Then, if I could invite you to go to our response, which is behind the next tab. And at page page 99, paragraph 3, we put the appellants to proof on this point. So to proof on each and every factual assertion contained within the statement of case, where facts are expressly admitted to apply, a submission in ASC is not responded to within the trial, is not an admission. And then, if I could invite you to go to tab 15 of that same bundle. So this again reiterates, this is a letter of the 24th of October 2018, second paragraph. So wholly exclusively is one of the live issues still. Burden, we say, stays with them. And then, if I could take you to
Don't we also, isn't it perhaps materials that go back and see actually what the revenues positive case was about TOAA in its reply? We don't find anything there about wholly and exclusively.
We did put in some further embedders. Let me just find those.
Well, you put in something halfway through the hearing. Nothing beforehand, did you? Or,
No,
anyway,
I
sorry,
didn't.
do please tell me, because I know one of the complaints made by Mr. Mullen is that really this was sprung on him by way of an ambush at the hearing.
No, my lord, and that's one of the reasons why I've taken you through this, which is
Well, so far, I see nothing to dispel the impression it was a bit of an ambush. So that's why I need to be quite clear where it is that you're taking this point.
my lord. Okay, so if we start with yes.
You say just putting to proof that that's enough, is it? I suppose.
Well, it's his appeal, my lord.
Well, all
and
right.
It's his assessment. There are live
Yes.
appeals here. The burden is on
But
him.
considering
It's an
any-
assertion that it's wholly exclusive.
Okay, and here we have reams of material about wholly and exclusively and so on, but those words don't appear anywhere in the revenues for tribe. Seems to be a bit surprising. That's such a major part of your case.
Well, my lord, we say that if I might put it in these terms, the consolidated statement of case. So the transfer of assets provisions are dealt with at page 79 of the bundle in the revenues consolidated statement of case as early as 2016.
Sorry, there are tab 11.
Tab 8, forgive me, my lord.
Tab 8.
Oh, tab 8, I beg your pardon, I'm looking at your reply. Tab 8.
And then you've got, as an alternative basis charge, this is where we raise the transfer of assets provisions for the first time.
Yes.
On the income arising person, the board will say that for the appellant to prove that he can benefit from the motive defence. That's where it starts. And then we have the appellant statement of case. Then we took you to our position at paragraph 3, which is to put the appellant as proof in the next tab.
Yes.
So he's asserted, wholly exclusively, we say we put you to proof. These are representative clients. They are asserting a position. They need to provide the evidence that proves the point. And then you see the letter from the 24th of October 2018, to which I took you at...
I'm sorry, could you just remind me which tab that was at?
Yes, of course. Tab 15.
Tab 15. Well, I must say, it seems to me it would, at the very least, it would have done no harm to make it clear that wholly and exclusively was going to be a major plank of the revenues argument. In explicit terms.
My lord, it is for the taxpayer to provide evidence to discharge their burden.
Well,
The
that's
burden is clearly on the taxpayer.
yes, but again, the purpose of these directions given by the FTT was to draw out the arguments with a view to neither side being taken by surprise. And since it is such a major part of your case, I would have thought that this was, on any view, by the stage when the FTT was directing the parties to state explicitly whether they had any further arguments up their sleeves. That might have been a good idea to say so.
My lord, if I could take you next to the skeleton argument of my learned friend, which is behind tab 24, and page 244 of the bundle. Reminds me that at this stage, by the time the skeleton argument got to be written, a concession had been made that ranges applied, so that it was now conceded that these were remuneration. So then you've got at paragraph 22 and 23, that's page 244 of the bundle. And paragraph 23, as regards the employer, the charge will be on his profits, and therefore would not include sums paid to the trust. So that follows, we say, the concession being remuneration, therefore there is a deduction. And then at paragraph 136 of our skeleton argument, which follows in the next
136. Oh, no.
So page 298, my lord. It's behind the next tab. It's our skeleton argument. Paragraph 136. The effect of the decision of bracket cannot be circumvented by asserting that the profits of the employers would not include sums paid for EBTs. The question of what is meant by income for these purposes was considered in Rotilla. Of course, they quoted Chetwood, which also quoted Rotilla. And the appellant is put to proof as to why it is alleged that such a deduction would be due and or has in fact been applied. So it wasn't that they were sprung into it. I mean, they are fully represented. They have somebody of the calibre of Mr. Mullen. He was alive to the Chetwood point. In fact, he tactically thought that having remuneration meant he was home free on the transfer of assets point. And the tribunal accepted it. Now, if I could just take you to, there's one other point. Take you to the unagreed bundle for the closing submissions, because it was quite a long hearing.
So those were the skeletons in advance of the hearing.
That's right. And
Yes.
then the closing submissions.
Yep.
We each of us put in closing submissions in writing, obviously, and someone did that. And if I could ask you to turn to page 6310, wrong page number 118. It's in the bottom right-hand corner.
Sorry, which bundle are we in?
In the unagreed bundle.
HMRC's unagreed bundle.
Yes.
Yep.
It's behind something called tab B. And this is Mr. Mullen's written reply. Paragraph.
Closing submissions.
Yes. Sorry, closing submissions. Thank you, Mandy. And the paragraph 2.1 talks about section 62. Paragraph 2.2 talks about accepting those RFCs. Paragraph 2.3 says a further consequence is that the payments to the trust were a deductible expense of the employer, since the TOAA code applies to charge the transferor on the income of the person abroad. It can have no application to sums paid into the trust. Such sums are not income of the person abroad. So that's how he put it. And we took the court to, as you might imagine, quite a lot of the law and the facts. And our response to that point is in the next tab, page 159. There's some interesting formatting, but please excuse that.
This is the respondent's speaking note on TOAAs.
We have three speaking notes for the tribunal, for the FTT, forgive me. One on transfer of assets, one on jurisdiction, and one on discovery. On discovery, because discovery was live at that point.
Yes, yes.
In fact, that took up most of the time, I would have said, in terms of evidence. Yeah, the speaking notes were handed up as part of the hearing, so that the tribunal had them to note as they were going through. So, if I could ask you to turn to page 159, paragraph 21, it is titled that income of person abroad is the trading company is the profits of the person abroad, not the totality, citing Chetwood, Rotilla, and then the appellant asserts computing profits of the appellant, one must allow a deduction.
Sorry, did you say 21?
I think 29.
Paragraph 29.
29, yes, sorry, I missed it.
point out that the appellant has adduced no evidence of what amounts it says are the profits of the employer, nor does the appellant explain why a deduction is due. It's well established that in order for a deduction to be made available to a trader in respect of payment, payment must be made wholly inclusive of the purchase of the trade, and then we talk about Allway and the sorts of things you'd expect to see, and then talk about Coke and Flood over the page. So, and then 33, to the extent, therefore, that there is duality of purpose in any payment, including the amounts later described as loans, i.e. whether analysed as a payment directly to the employee or as a payment to the EPT by Penfolds Hamilton Trust, and B, the payment of any fees, the payments are not permissible deductions. So we were fully in dispute here, and it wasn't a question of being bounced into it at the hearing. But what the point that I wanted to take you to was the way in which my learned friend put it in his closing reply, which is clause 2.3, which is because of the ranger's concession that it is remuneration, it is therefore deductible. And that is how we say that Tribunal found the way it found. It too looked at RFC and then said, this is just a payment of salary, therefore it's deductible. And they didn't ask themselves what other purpose there might be. They didn't recognise the importance of looking into the directors' minds to see what the purpose might be.
Well, they didn't expressly do so. I mean, given that they'd been fully instructed about the relevant law, isn't it fair to assume that they would have considered that point, but came to the conclusion that the fact that it was remuneration on the facts of this case were enough to tip the balance in the taxpayer's favour on this issue?
My lord, they had no evidence from one employer at all. Nobody from Penfolds came. They didn't mark that as something that was missing in making an analysis solely and exclusively for the purpose of Penfolds trade.
I do understand that point, but it is quite hard to see why would the employer come? The employer has no skin in this game, and Mr. Hoey has no means of compelling the employer to come along to the tribunal, and nor does Mr. Hoey have a means of getting information out of the employer. It's the revenue who have, as my Lord Justice Henderson said earlier, the information powers available.
The employers here were non-UK resident, my lady, so the ability to use Schedule 36 didn't exist. The revenue used the information powers that they had in order to get the information from the Isle of Man. So, the Isle of Man matter was a mutual assistance. They did try and get documents. They got quite a lot of documents, but they don't go to the purpose of the employer. This is the point. All the cases show that you have to inquire very carefully. You have to look into the minds of the employer. If the employer isn't even there.
But it's quite hard for Mr. Hoey to. How does Mr. Hoey address that?
Well,
he's not the employer.
My lady, Mr. Hoey wasn't on his own. This was a Rule 18 case. There were Matt Hall was there as part of these arrangements and part of this application. It wasn't like, for instance, the case of Boyle, where he was entirely divorced, as it were, from the entire structure and had no input from the people who had arranged the structure. This was a situation in which there was a Rule 18 direction. Mr. Hoey was the lead case. There was supposed to be, I think, also Mr. Jones, who was supposed to be a lead case, but he dropped out at some point. And so the revenue cannot be impugned for not using Schedule 36, given that the employers were offshore.
No.
They used what they could. That said, one employer did show up, Mr. Parr of Hamilton Trust, and his evidence, and I can give you a note of all of his evidence. Perhaps I can read it into the transcript, and it might save time tomorrow. I don't know. I'm just conscious that we're coming towards the end of the day, and I don't want to lose the opportunity to put the evidence before you. That he knew very little about anything. He didn't even know the amounts that were to be. He didn't know what amounts were to be paid to him. He didn't know what amounts were to be paid out to the EBT. That was all determined by the enforcer. There are other bits of evidence like that. And what evidence there was from an employer didn't show that there was a trade purpose. All it showed was this employer was taking part in a scheme to facilitate Mr. Hoey getting 80% take-home pay, as opposed to a lesser amount because of the tax But
the
it's
scheme wasn't set up by Mr. Hoey. And Mr. Hoey was a participant in the scheme, but you can't say the purpose of the scheme was so that Mr. Hoey could get 80%.
Mr. Hoey was a representative, my lord, a representative case. There were lots of other taxpayers. Rule 18, so there are loads of followers behind it. There's a Rule 18 procedure here. So he's not, as it were, a lone entity being, having the wrath of the world visited upon him, or the wrath of the government visited upon him. It's not that at all. This was a scheme that was operated, which had multiple users. The scheme operators put forward Mr. Hoey as the representative. And Mr.
My lord, I hesitate to interrupt, but that's simply not true. Mr. Hoey was not put forward by anyone, and Mr. Hoey has no contact with the scheme operators beyond what he's been able to manage for the purpose of this case.
He doesn't represent the scheme in any way.
He isn't. No, he's as far as we understand, he's just a user of the scheme. But Mr. Matt Hall was there, who was a deviser of the scheme. And I believe, but if those behind me will correct me if I'm wrong, has been involved throughout in the discussions with the revenue on how to progress this matter towards a resolution. Now, that may be, I have an assenting nod from the back, but I can perhaps come back to you on this point. Mr. Hoey is not, as it were, all on his own and cannot be expected to give evidence. He's given evidence of what he was involved in.
I don't think that was really my point. I think you're suggesting that the purpose of the scheme is to provide the benefit to Mr. Hoey, but Sorry. The purpose of what was being done was to provide benefits. But I don't think that is the purpose. It may be that the purpose of the scheme is to, or certainly for the trade, is to provide services to the end users, and through so doing, plainly to make money for somebody at the end of the day. And this wasn't being done for love. And in particular, it wasn't being done for the ultimate benefit of Mr. Hoey. Providing the benefit of Mr. Hoey was how they persuade him to sign up. That's not the purpose of any of it. That is an effect of it, and it's an element of an important element of the scheme, but in no way is it their purpose to benefit.
My lord, if I could just take you to the scheme documentation. Which we would say makes it absolutely clear that the purpose of the arrangements was to provide Mr. Hoey and people like Mr. Hoey.
That's the marketing material. That's the marketing material, isn't it? We're saying it's just like somebody selling goods to the public will say, we want to provide you with the best possible whatever you're selling, but the purpose is to make a profit from selling, not to.
Except no profits were made. Let me put it this way: there was an intentional, there was a finding of nil profits. Included in that finding was the fact that Mr. Parr's Hamilton Trust doesn't retain profits. Included is the fact that there are arrangements, that part of these arrangements ensured that the profits didn't stay with the offshore employer. They were earned by intermediaries elsewhere. So the two people who financially benefited from this were not the employer. And it begs the question, in what way can that be justified as being for the purposes of the employer's trade? As you say, it's not a charity. It's not doing it for love. If it's an enterprise, what's it doing it for? And the reason it's doing it is to facilitate the tax avoidance on the part of Mr. Hoey, and on the way to ensure that fees arise elsewhere.
It was plainly designed to earn fees for persons or persons may be unknown. I don't know, but it certainly isn't being done with it. It certainly isn't being done for the benefit of Mr. Hoey in the sense of that is the aim of it. That may well be the effect, and it may well be an important element of how it's set up and structured. But that's not. Mr. Hoey hasn't set this up, and Mr. Hoey doesn't have any interest in it. He's simply effectively a customer of the scheme.
My lord, if I might just say this, the fact that profits are engineered to be earned elsewhere is sufficient to mean that this is not wholly exclusive for the purpose of the trade. It's exactly the same point, my lord. It's exactly the same point. In order for this deduction to be possible by the offshore employer paying the contributions to the employee, it can only have trade purposes, its own trade purposes. If it is making sums available to other persons, and those are engineered as being part of these arrangements, it does not have a trade purpose when it's doing that. And that is sufficient to deny it the deduction. Quite apart from which we say, the purpose of these arrangements is so evident from the Provis document, which is marketing. Of course it's marketing, but what it is doing is seeking to ensure that Mr. Hoey and people like him who can take part in the scheme will receive a tax advantage by entering into these arrangements. And because the enterprise doesn't benefit from doing that for Mr. Hoey, it doesn't earn any profits for itself, that cannot also have been a trade purpose for its trade, for whose ever trade perhaps, but not for its trade. That too, we say, is sufficient to deny it the deduction. It doesn't matter, my lord, that Mr. Hoey didn't design the scheme. He doesn't have to be the one designing the scheme. The payer of the amount needs the deduction in order for the profits and the income of the person abroad that is attributed to Mr. Hoey to be zero. It is integral in those arrangements that they get that deduction. But in order to get that deduction, they need to show that it's for their trade. And they can't show it's for their trade because they do not benefit financially from it. Profits arise elsewhere as part of these arrangements, and Mr. Hoey receives this benefit, this tax saving. When one looks at the Penfold Employee Information Guide at tab 4, one sees that is so definitely the purpose for which the arrangements were engineered. And the reason I'm asking you to look at the purpose for the arrangements is because it is relevant to determining the purpose of the payer, as we've seen from Scots Atlantic at paragraphs 80 and 81. You can't look at the payer's payment in isolation, we say.
Well, all Scots Atlantic shows is that on the findings of fact in that case, there was no error of law with which a higher court could interfere. We're in the converse position here, where we have findings of fact that there was deductibility, and you have to show an error of law in that. And the mere fact that the fees are paid to a third party, I can't at the moment see why that should necessarily throw any light on the matter. I mean, that just shows how the company decides effectively to use its profits or to arrange matters in such a way that profit is perhaps earned by somebody else at some other stage of the overall scheme. But that doesn't go to the purpose for which the payments into the EBT are made. I just can't begin to understand it.
I'm going to have another go, my lord. Let's hope I can make it clearer. What we say is this: there can only be a trade purpose on the part of the payer in order to get the deduction. Wholly and exclusively means exactly that. If even one purpose, however minuscule and however small the amount that ends up somewhere else, even one purpose of ensuring that monies are earned elsewhere and not by the payer is a non-trade purpose on the part of the payer. See Vodafone, Cellular and Shaw. Because there the focus was on what is it that it benefits the payer company here, the parent company. And here we have evidence. We say that the funds where they arose, profits where they arose elsewhere. That we say is enough to deny the deduction. But we say that it's also so clear that the purpose of the payments cannot be divorced from the purpose of the arrangements, which was to ensure that Mr. Hoey received this tax benefit. That is also a non-trade purpose, unless it can be shown, and this is why I wanted to take you to Orway, unless it can be shown that achieving this tax avoidance purpose would have benefited would have been for the purpose of the paying company. But maybe I could just, I'm conscious of the time, but if I could just show you that and leave you to think about it overnight, and we can resume again tomorrow. But if I could just take you to Allway, which is behind tab 31 of the bundle of authorities. It's the main bundle of authorities. And this is a case involving a structured scheme where payments were made into an EBT by owner-managed companies. And perhaps it might, I'm not sure whether I can trespass on your goodwill for more than 5 minutes.
Yes, certainly.
Perfect. So
Is this an FTT decision?
it is an FTT decision, but the reason that I've taken you to it is to show you the sorts of evidence that somebody properly instructed as to the correct test would be looking for. And so if I could take you to overall conclusion on deductibility, that starts at paragraph 131, page 786. So if I could invite you to read 131 through to 133, please. And so we say a tribunal properly instructed as to the correct test would be looking for the sort of evidence, even in an avoidance scheme, of the sort identified at paragraph 132. I'm not purporting to make a general statement to the effect that providing tax benefits to employees can never be wholly and exclusively for the purpose of the company's trade. For example, if a company can demonstrate that an employee would be prepared to work for a lower salary if that salary could be paid tax-free, it is conceivable that the company could establish that its object in making a tax-free payment was wholly and exclusively for the purpose of the trade. However, JCN has not put forward, etc., etc. So if a tribunal had been alive to the question, not simply that it's remuneration, but is there anything else that it might be? And if it had recognised the importance of looking into the director's minds to establish that purpose, not simply looking at the fact that it's remuneration, it would not have made the finding it did, certainly not as briefly as it did. It would at least have tried to address, we say, some of the facts that might be relevant, or address the fact that it would have liked to see something else along these lines, but it didn't. Nevertheless, the fact that it didn't do any of that, but it simply went from the quote from RFC into therefore it's wholly deductible, we say is entirely evidence that they made an error. Would this be a convenient moment this evening?
Yes, thank you. How are we doing just in terms of time? We have bombarded you with questions.
I think what I'll do, obviously I have to come back to you on the other point. What I have to do is perhaps see how much of this I've now covered, so I don't need to take you into it. We still have the whole of the EU matters to deal with.
Yes.
I think my Eleanor June is right. We probably do need most of tomorrow morning, but I think we were scheduled tomorrow morning anyway.
Oh yes, we are. I'm just.
We were scheduled to finish at 3:15 tomorrow afternoon, so you've got till.
No, but we're not doing. We're not sitting tomorrow.
No, we were scheduled to finish
Yes.
at 3:15. But you started us. You've got at least till lunchtime, possibly a quarter of an hour more.
Yeah. So you think you'll complete by lunchtime?
Certainly hope so,
Yes.
my lady.
All right. Good.
Can I
Well,
ask
then-
on the EU point?
Yes, of course.
I can see you got Fisher in.
Yes.
Okay.
We've got your dissenting decision on that as well.
And in relation to the EU point.
No, it was in relation to the procuring on the
Yes,
transfer point.
but the EU point was considered in the Court of Appeal as well.
It's that concerns freedom of establishment. We're not concerned with freedom of establishment at all. And we
No.
say, therefore, it isn't relevant.
It's not
to
relevant.
these.
No. Thank you.
Right. Good. Very well. 9:30 tomorrow morning.